Hello, this is Scott Horton. I will be giving today's presentation on the New York Employment Law Update for 2024. I've just opened the room for attendees to join, so I'm going to allow a couple of minutes for everyone to do that, and then we will get started as close to the scheduled start time as possible. So far, it looks like everyone is able to join, or at least a number of people have been able to join. So hopefully everything is going smoothly with that. We're just going to allow everyone to get into the room and then we'll get started. You should have access to a chat window where you can type in questions that will be answered primarily at the end of today's presentation. I encourage everyone to type in questions as you have them. And again, we'll get started with the formal presentation in just a moment or so. Looks like we still have a steady stream of people joining, so I'm going to allow another minute or two for that to happen. Otherwise, you should be able to see the cover slide for the presentation 2024 New York Employment Law Update on your screen. And if you have that and access to the chat room where you can type in any questions that pop up as you're going, then you should be in good shape, assuming, of course, you can also hear me. But if you could not hear me, then it wouldn't matter what I was saying anyway. Today's presentation is scheduled for an hour and a half. In particular, if you are eligible for and interested in your HRCI credits, there's an hour and a half of credit pre-approved for this presentation. So we will go approximately that amount of time. As always, I will try to stay on as long as possible to answer any questions if they're still coming in beyond that point. We're going to get started in just probably another 30 seconds. I just want to make sure everyone who is trying to log in right now is able to do so. Okay, at this point, we're leveling off on people joining in. So I'm going to assume that a few more will continue to join, but I'm going to go ahead and start with the overview. Again, I'm Scott Horton. I'm a partner with Gunnar Cook, LLP. I run a website that includes a blog and other links to information like these webinars and announcements about them through Horton Management Law, which is available at hortonpllc.com. Today's webinar, again, is going to be about an hour and a half with a question and answer at the end. If you have any questions, please enter them as you go. If I happen to see them at a time where I'm able to address them in the course of the presentation, then I will try to do that. Otherwise, I will save most of them for the question and answer segment, keeping in mind that if you have any highly specific or potentially confidential information to address in your question, there would not be any attorney-client privilege in this format. At the end, you will get my contact information in case you don't already have it. And if you'd like to reach out to me that way, you're certainly welcome to do that as well. Today's presentation is a New York Employment Law Update for 2024. We're coming up on about midway through 2024, so I thought this would be a good opportunity to discuss what is going on with several significant items both at the federal and New York state level. So while I'm calling this the New York Employment Law Update, that just means it's geared toward employers in New York, but we will be addressing significant federal issues as well. There are going to be several topics, and in a sense, we'll be kind of bouncing back and forth and around between New York and federal issues, but there's just a lot to talk about. I've tried to come up with the best framework possible to make all this make sense. If you are with a nonprofit or a government employer, then some of what we address may not apply to you. And certainly even within other private sector businesses, based on your size or industry, there may be issues that we discuss that do or don't apply to you. And I will do my best to point out those distinctions, but just in case I don't point out a relevant distinction, just always be sure that whatever legal issue I'm discussing does actually apply in your situation. Again, if you have questions about that, please ask. First, we're going to talk about the Freelance Isn't Free Act. This is New York legislation that will take effect now August 28th of this year. So the New York State Freelance Isn't Free Act is a state law that will apply generally across the state. There was originally a provision of the New York labor law that was going to take effect much earlier and would already be in effect now. That got delayed by an amended piece of legislation. So now this is addressed in the general business law at section 1415 for anyone who needs to obtain that statute. In addition to what I'm going to discuss today, for those of you with employees in New York City, you may be already familiar with the New York City Freelance Isn't Free Act, and that has been in effect since May of 2017. I think I referenced employees in New York City. Specifically, the New York State and New York City Freelance Isn't Free Acts are designed to address employees who are not, in fact, employees. So what types of individuals are being addressed by this legislation? Well, it defines the term freelance worker based on these various points. First of all, it's any natural person or organization composed of no more than one natural person. So a business entity, a corporation or LLC that has multiple owners or staff members, employees, etc., does not count as a freelance worker. However, if a single sole proprietor of a business that is just the one person happens to be incorporated or have an LLC, which is certainly possible and common, then they can still be, through that entity, a freelance worker. As the next point indicates, they don't have to be incorporated or have a business name to be considered a freelance worker, but if they do, that does not preclude them from being a freelance worker under the law. This freelance worker is hired or retained as an independent contractor by a hiring party to provide services. So what we're ultimately talking about here relates to the distinction between employees and independent contractors. Employees are covered by other legal parameters, and this Freelance Isn't Free Act is not trying to duplicate or replace what the labor laws already cover. It is designed to extend protections to workers beyond employees who are considered independent contractors. The hiring party presumably is your business or the employer slash hiring party of an independent contractor, and we'll go into that definition more in a moment. The freelance worker has to be providing services in exchange for an amount of at least $800. And that $800 threshold is either based on an individual service or payment, or when you aggregate all of the contracts for services between that same person and the same hiring party in the past 120 days. So if you were paying someone $100 a week, for example, then over the course of 8 weeks, you would get to $800, and this Freelance Isn't Free Act would be triggered because that 8 weeks is less than 120 days. There are some categorical exclusions. First of all, sales representatives are already covered by a provision of the New York labor law. Again, these are sales representatives defined separate and apart from employees. So obviously you might have employees identified by title as sales representatives, or that is the nature of their work. There are other provisions and requirements under the law for employees who are commissioned salespersons, for example. So some of this obviously can get a little confusing, but independent contractor, sales representatives are not covered by the Freelance Isn't Free Act if they meet that definition of the labor law, because there's already statutory requirements for contracts and payment there. Lawyers who are legally practicing law are excluded. In other words, if you hire a lawyer who happens to be a sole practitioner, then they might otherwise meet the definition of the Freelance Isn't Free Act, but the law will not apply as long as you're hiring that lawyer to practice law in a way that they're authorized to do. That being said, if you hire the lawyer to do something that doesn't have anything to do with practicing law, to file papers in essence that aren't filing legal papers but are just literally organizing your files, then the law could still apply. Licensed medical professionals are excluded. So obviously doctors and nurses are the primary categories there. And construction contractors are also excluded. Relatively uncommon to have individual construction contractors. More often, they're going to be part of a business entity that's larger than one person, but there certainly are single person construction contractors, and they are not covered by this law if that is the case. What is a hiring person? Well, it's any hiring party, any person who retains a freelance worker to provide any service. So that is pretty broad. The clear exclusion is for government entities. So any person means you don't necessarily have to be a business. If you hire someone to perform work at your home, for example, you are still a hiring party. And if the other conditions for that person being considered a freelance worker apply, then the provisions of the Freelance Isn't Free Act are going to apply. Note that government entities are excluded, which I guess is a nice side effect of the government creating these laws, is that they can carve the government out of coverage if they choose to do so. So if you do work for a town, village, county, public authority, then you're probably not subject to the Freelance Isn't Free Act in that capacity. Again, you may be subject to it if you're personally hiring someone to perform services for you in your independent personal capacity. So why does it matter if the Freelance Isn't Free Act applies? Because if it does, you have certain contractual and payment obligations. Namely, if you are going to engage a freelance worker and you're going to meet that $800 threshold, then you must have a written contract governing that relationship. These items of information must be included in that contract: names and mailing addresses of both parties to the contract, itemization of all the services to be provided, the value of those services, the rate and method of compensation, the date or mechanism of determining when payment will be made, and the date by which a freelance worker must submit a list of services rendered to allow the hiring party to process timely payment. Now, different of these items are going to be more or less common or easier to include. In some cases, there's going to be a flat fee. Person does X and the pay is Y. In other cases, as the last item on this list demonstrates, you won't know exactly what the total payment is going to be until after the work is done. And the different requirements here are designed to somehow collectively encompass all the different circumstances. So it may be that there is never going to be a submission by the freelance worker of a list of services rendered, and that's not necessarily going to invalidate the contract. The point is, if that's relevant, then it needs to be included. Presumably, if that's not relevant, then the terms are going to otherwise make it obvious that that's not necessary. For example, but what are the consequences of not having a contract, or in essence, not having a compliant contract by including the required terms? Well, in that case, the freelancer can assert a violation of the act just on the basis of not receiving a contract. But to assert that type of claim, the freelancer would have had to have requested a contract before beginning the work. So the burden, to some extent, is on the freelancer to request a contract. And if they didn't, but do the work anyway, then they can't make a claim for failure to provide the contract. However, even if they didn't make the request, the hiring party would still be at risk of evidentiary presumptions in the freelancer's favor if there was, in fact, no written contract. In other words, the ultimate burden is on the hiring party to ensure that there is a compliant contract, because if they don't, then the freelancer is going to be given more discretion in offering what they believe the arrangement was intended to be. And again, if the hiring party refused to provide a contract after the freelancer asked for it, the fact that the freelancer then nonetheless went on and performed the work isn't going to be held against the freelancer. At that point, it's going to be held against the hiring party, up to the point that there's even a claim just based on the not having a contract, independent of whether the hiring party makes good on what the arrangement was actually intended to be or not. The law ultimately is trying to get at what other provisions of law do to protect workers by being paid what they need to be paid. In other words, if you have an employee, New York state law is going to require that person be paid within a certain amount of time, all amounts that they're entitled to be paid, but there's otherwise no general statutory provisions that require the independent contractors of the world to be paid or provide for damages if they're not. Now, certainly there could be breach of contract claims, for example, in those situations, but they don't have the full range of remedies available as employees would in cases of non-payment. So the law is specific that Payment must be made either by the date specified in the contract, or if it's not specified, within 30 days of completing the freelance worker's services. So that's not to say that all payments have to be made within 30 days of the work being performed, but if there's not a contract or the contract isn't clear to that point of when the payment is supposed to be made, then the 30-day presumption will apply. The law also prohibits hiring parties from demanding that freelancers accept less compensation than contracted as a condition of timely payment. Now, there is some potential uncertainty here in the case of a contractor who doesn't provide the services that were expected, and I would encourage hiring parties to ensure that their contracts address that scenario as clearly as possible. But ultimately, if there isn't a contract or the contract isn't specific enough to demand certain performance, then once the freelancer says they've completed the job, then there's a risk if the hiring party doesn't make payment in full in a timely basis. And at that stage, the law is saying the hiring party doesn't have the liberty to go to the freelancer and say, if you want to be paid on time, you're going to accept 80% or whatever of the original offer. So what are the penalties? Basically, the law borrows from the wage payment remedies under New York labor law. So where historically, if an independent contractor is not paid, they would have a breach of contract claim, and a breach of contract claim might allow them to recover their actual loss from not being satisfied on the contract. Breach of contract claims typically don't include things like double damages or recovery of attorney's fees and costs, which are more typical of wage payment laws, including New York's wage payment laws. So now the statute will allow the contractor who's not paid what they believe they should have been paid to sue and potentially recover double damages, either for late or for non-payment, as well as their attorney's fees and costs. It also provides that there's a 6-year statute of limitations regarding the payment issue, which is consistent with the 6-year statute of limitations on breach of contract claims. There is a shorter 2-year statute of limitations on the claim of failure to provide the contract. So if the claim is just the technical violation of I requested a contract and they didn't provide me one, then there is a cause of action there, but that would have to be brought within 2 years. The main reason why the effective date of this law got pushed back is the governor didn't like the original legislation that was going to give the Commissioner of Labor the right to enforce this new statute. Instead, the compromise was that the Attorney General's office can enforce it, in addition to the freelancer having their own right of action to pursue a lawsuit if they so choose. And when the Attorney General pursues it, they can seek civil penalties, fines that would be payable to the state. Basically, Governor Hochul said that this would put too much of a burden on an already strained Department of Labor. So for those of you who have other dealings and cases and relationships going on with the Department of Labor, or you wonder about different guidance that they provided or haven't provided, then the governor is basically conceding that they are overworked and understaffed for keeping up with all of the new regulations and restrictions that the legislature has decided to put on employers. As with most of these types of laws, retaliation is also prohibited. So if someone does make a claim for payment, you couldn't use that against them, even for the purposes of, say, not wanting to contract with them in the future, in similar ways that you couldn't retaliate against employees. So it really does serve in numerous ways to treat independent contractors more like employees without specifically changing the standard between who is an employee and who is an independent contractor. Okay, now we're going to move on to one of the big hot topics that under different circumstances I might have led this presentation with, but for reasons that I'm going to get to in just a moment or two, it wasn't quite worth being the number one item on the list, in my opinion. So the Federal Trade Commission has taken recent action regarding non-compete agreements. Most of you are already familiar with that. We'll get in a minute to exactly what the new FTC rule provides. But just to give a little bit of background, what we're talking about is something that falls in the category of contractual clauses or provisions known as restrictive covenants. Restrictive covenants are primarily governed by state law in the United States. So non-compete agreements or non-compete clauses are one type of restrictive covenant, generally considered to be the most restrictive of these covenants or provisions. And therefore, enforcement of non-competes has historically varied from state to state, with some states, notably including California, essentially prohibiting non-compete agreements altogether, and most other states requiring a fact-specific analysis of whether a given non-compete agreement should be enforced in a particular circumstance. There are also restrictive covenants in the form of non-disclosure, also known as confidentiality provisions, and non-solicitation provisions. These are generally more widely permitted. For example, a non-solicitation provision might say that a person is not allowed to solicit business from a customer of their former employer for some period of time following the end of that employment, where a non-compete goes further and doesn't just limit soliciting actual customers, but would intend to prevent the person from competing against that business generally, even against non-customers or merely prospective or potential customers. So how did we get where we are with the FTC? Back in 2021, President Biden issued an executive order in which he said the chair of the FTC, the Federal Trade Commission, is encouraged to consider working with the rest of the commission to exercise the FTC's statutory rulemaking authority under the Federal Trade Commission Act to curtail the unfair use of non-compete clauses and other clauses or agreements that may unfairly limit worker mobility. So the FTC's authority addresses generally unfair business practices, primarily designed to, for example, promote monopoly activity. So this reaches into the realm of antitrust activity. But the FTC has never really directly been involved with non-compete agreements. But this is what President Biden suggested they should be considering a few years ago. As a result, in January of last year, 2023, the FTC issued a proposed rule saying that it is an unfair method of petition. This UMC is sort of a term of art in FTC regulation and law. For an employer to enter into or attempt to enter into a non-compete clause with a worker, maintain with a worker a non-compete clause, or represent to a worker that the worker is subject to a non-compete clause where the employer has no good faith basis to believe that the worker is subject to an enforceable non-compete clause. In other words, the proposed rule says non-compete clauses are illegal in the United States. If you have one, then it's no longer valid, and you can't suggest to your employee or former employee with whom you have such a non-compete clause that it is still valid, unless you somehow have a good faith basis to believe that they were subject to an enforceable non-compete clause, which, as I'll get to, there is a reason for putting that in there, but it won't apply in most circumstances. Fast forward to May of this year. So a few weeks ago, actually it was in April when the FTC voted on its final rule, but it was officially published, which is relevant, May 7th of 2024. The publication then triggered the effective date. So it is scheduled now to take effect September 4th of this year. And this final rule is indeed a broad ban on post-employment non-compete clauses. So technically, non-compete clauses usually say that during the course of employment with the employer and then for some period thereafter, the employee cannot work in a competitive business. Well, the FTC is not trying to say that you can't prevent an employee from working for a competitor while they're working for you. They're focused on the part about what happens after they leave your employ, and they're now saying that you can't prevent them from working for a competitor. Pretty much full stop with very few exceptions. So this is certainly very game-changing compared to the case-by-case general allowance of limited non-compete clauses throughout most of the United States. Notably, the rule does refer to workers and is not limited to employees. That's one of the reasons why I wanted to address that Freelance Isn't Free Act first, just to sort of prime the distinction between employees and other types of workers, including independent contractors. So this FTC rule would also apply to those independent contractors, for example, subject to the Freelance Isn't Free Act in New York. The laws are not connected in any specific way. Obviously, that's New York law, and this is federal. But just, again, to make the point that where there are distinctions between employees and independent contractors in a lot of contexts, this FTC rule does not really make that distinction. The final rule also requires that anyone who is party to a non-compete with a worker would have to give notice to such workers that any existing non-compete clauses cannot be legally enforced against the worker. There is, in fact, a whole sample notice that the FTC has issued. You don't necessarily have to use the sample notice. You may or may not want to if you get to that point. But in other words, effective September 4th, and by that date is what the rule actually says, any entity that has or person that has a non-compete in place with a worker is supposed to notify them in writing that that non-compete will not be and cannot be enforced. Coming back to whether you're going to actually have to do that in a minute, let me just let you know what the rule refers to as a non-compete clause. It is defined as here, a term or condition of employment that prohibits a worker from, penalizes a worker for, or functions to prevent a worker from seeking or accepting work in the United States with a different person where such work would begin after the conclusion of the employment that includes the term or condition. Again, so this is a post-employment restriction on work. The limitation to the United States is presumably just based on the extent of the FTC's jurisdiction. The other protection is that you can't limit them from operating a business in the United States after the conclusion of the employment that includes the term or condition. So either working or operating a business, to the extent that you want to split hairs and say that owning or operating a business is not the same as working, the FTC is clear that both of those can be considered non-compete clauses. There are some exceptions, and the first of those is potentially somewhat broad, and that is non-competes entered into as part of a bona fide sale of a business. A bona fide sale of business means an arm's length transaction, which basically means it's a legitimate sale, not some sort of sale that the employer has fabricated in essence just so that they could bind a worker to a non-compete. It is notable that this isn't limited to owners of the business being sold. So it is possible that employees of a business that has been sold in a bona fide transaction could be subject to a non-compete. So that is a potentially legitimate, or I should say meaningful exception. But again, most non-competes are not related to the sale of a business. Those that are historically have been protected or enforced, I should say, more broadly than those that are just based on an employment relationship. So it's not entirely surprising the FTC is treating them differently. There are a bunch of other nuances to that if it were to take effect that may come up and would have to be analyzed if you were in that situation. There's also an exception, and this is a very limited exception by contrast, to existing non-compete clauses with senior executives. First of all, this is only for non-competes that exist at the time the rule takes effect, which is scheduled to be September 2024. So if there is a non-compete that's already in place, then that non-compete can be enforced apparently indefinitely if the person is a senior executive, meaning that their annual compensation at the end of employment was at or above the level of $151,164. There's more guidance on how to determine annual compensation if that's relevant. And the person also has to have been in a, quote, policy-making position. This policy-making position, again, is a very limited category, which in most cases essentially means they're the president or CEO of a business enterprise. There's language that suggests that the president or CEO of a subsidiary to a bigger business enterprise is not even subject to this exception. It would have to be the CEO or president of the ultimate company of a multi-layered business enterprise, apparently. The final exception is to note that there are many nonprofit organizations that are generally outside of the FTC jurisdiction. So a pure nonprofit that's not engaging in certain commercial business, through a subsidiary or division or something like that, may be entirely excluded from coverage of this FTC rule. The most common scenario where this could apply would be for hospitals, as most hospitals are organized as nonprofit organizations and may meet the exception here. So to the extent that there are doctors or executives in hospitals that have non-compete, this may not be affected even if the FTC rule takes effect. All right, so here's the big issue. The rule has been published and finalized. If nothing else happens, it would take effect as of September 4th, 2024. However, as was always expected, there have been multiple cases filed seeking to block the rule. There are at least 3 known relatively prominent cases. The Northern District of Texas is expected to issue its decision by July 3rd, 2024. Obviously, trying to beat the July 4th holiday, but also recognizing that there are real consequences if this rule is still on the books by or approaching the September deadline, including the obligation for presumably hundreds of thousands of notices to go out letting people know that their non-compete is no longer enforceable. The judge in this Northern District of Texas case, which has numerous parties now, including the U.S. Chamber of Commerce seeking to strike down the rule on various legal theories, is a Trump appointee who is therefore presumably a Republican under the circumstances. The Texas courts have traditionally been willing to strike down federal agency regulations. So for a combination of reasons, it's widely anticipated that this rule may in fact be blocked by July 3rd. The fact that it's blocked by July 3rd doesn't necessarily mean that it would never take effect, but it probably would effectively mean that it won't take effect in September. There obviously could be appeals, potentially all the way up to the Supreme Court. If those were to take place, they likely wouldn't take place before the election in November is decided and a new presidential term begins. Of course, that could be 4 more years of a Biden administration, or it could be 4 more years of a Trump administration, or, hypothetically, it could be something else. All that by way of saying that we know where Biden currently stands on the FTC and non-compete based on the statement I gave you earlier. It's quite fair to assume that any Republican president and administration would come in seeking to undo this rule immediately. So a couple of things: what happens in the courts and what happens in the elections are likely to determine whether this ban ever actually takes effect, but you will have to stay tuned to that if you have these types of agreements in place or generally use them, as well as if you are in a position where you potentially hire or have current employees who are subject to non-compete agreements from prior employers, because that could also be relevant on what they can or can't do by way of working for your organization. I should note that the New York State legislature, in fact, voted to ban non-competes in 2023. There were parameters that were somewhat different than the FTC rule, but ultimately Governor Hochul did veto that legislation last year. It's probable that some of the reason why New York hasn't yet adopted some form of non-compete ban is that this FTC rule has been pending, and they probably saw some logic in letting the federal government take the lead rather than come up with their own legislation that might be subject to challenge or at least create some sort of political consequences. That being said, Governor Hochul did indicate that she might support a similar bill banning non-competes for effectively lower wage employees. In other words, she suggested a cutoff for executive non-competes with some sort of salary threshold that might be in the range of something like $250,000, so higher than the federal threshold, but this would be not just for existing non-competes. It would allow future non-competes, and it wouldn't necessarily require the policy-making position at the level that the federal rule does. So even if the FTC rule fails, there's certainly a decent chance that the New York legislature is going to do something to ban non-competes in New York. And in fact, there's some speculation that if the FTC rule conclusively fails, then a number of states will use that as impetus to create their own non-compete bans of some extent or another. Okay, so from one controversial federal rule to another. I'm sure almost all of you by now have at least heard of the FLSA's latest overtime rule. Before I go directly into what that rule says, most of you are already familiar with it anyway, I just want to throw a reminder of where we are in New York. So under New York law, there is a state minimum wage that depends on where you are within the state, with New York City, Long Island, and Westchester being at $16 per hour, and the rest of, call it upstate New York, at $15 per hour, with future increases of 50 cents per hour over the next couple of years scheduled. Then the administrative and executive exemptions under New York law have salary thresholds currently of $1,200 per week or $1,124.20 in upstate New York. So this is where New York is. Again, those salary thresholds also increase on an annual basis over the next couple of years. So with that backdrop for New York, we get to the details of the new federal rule. Again, most of you are probably familiar with the FLSA, which is the federal minimum wage and overtime law. In fact, also has some other provisions, including child labor protections. But for our purposes, we are talking about the overtime exemptions, and all the rule addresses is the salary or monetary requirement to meet those so-called white-collar exemptions. It doesn't affect anything about minimum wage, and it didn't address any of the duties, tests, or requirements for those exemptions. Currently, the overtime salary threshold under the FLSA is $684 per week. I put the annual number on the screen, but the law specifically requires that the salary be paid per week. I mean, you can pay it less often than weekly, but on whatever basis it's paid, it has to meet at least that weekly threshold. In other words, if you pay someone every week and you pay them less than $684 per week, you can't generally say, but I'm going to make a catch-up payment at the end of the year to ensure that they meet that threshold. In other words, that's not typically a problem, especially in New York, of course, because you're trying to, in most cases, also meet the New York salary thresholds, which are much higher than $684 per week. The proposal has a couple of increases scheduled. One, very soon, July 1st, 2024, would raise the weekly salary threshold to $844 per week. And then on January 1st of 2025, raise it another nearly $300 per week to $1,128, which gets up to almost, but not quite, $60,000 on an annualized basis. The other component of the proposed rule is that beginning January 1st, 2027, there would be automatic indexing of the threshold every 3 years. In other words, taking effect January 1st, 2027, then taking effect January 1st, 2030. These would then be based on the average rate of salaried workers in particular demographic region, lower wage demographic regions of the U.S. Because of the way it's calculated, barring something incredibly unlikely occurring, the triennial indexing would almost automatically mean increases, and potentially significant increases, because as employers continue to increase salaries to meet the already increasing threshold, that increase will continue to drive up the average salary rate, which will then mean an increase in the requirement. Briefly, there's also a highly compensated employee exemption under the FLSA that has a relaxed duties test for certain particularly highly paid employees. Those thresholds have also been proposed to change from 107,000 and some change now to 100 and almost 33,000 July 1st to over 151,000 January 1st, again with automatic updating every 3 years. The New York law doesn't actually have a highly compensated employee threshold. It's actually a little more complicated. That's not to say you can't entirely, or you can't to some extent rely on that threshold within New York, but just so you know, there's not the comparable exception to point to, because here is my next point. Here is a slide showing the current and scheduled increases for the FLSA, and then, if you will, downstate and upstate New York, respectively. So as you can see, currently the New York threshold is well above the FLSA threshold, and that will remain the case through the scheduled increases for New York that take place up to January 1st, 2026. What happens beginning January 1st, 2027 is currently unknowable under both state and federal law. Again, the federal law as currently proposed would presumably increase on that date, and it's likely that New York State will also be making increases as of that date, but we can't know what those numbers are. It's likely that one way or the other, New York State is going to stay ahead of the federal requirement. So with all of that being the case, that one might say, well, why does this even matter to those of us who are New York employers? So certainly some of you may have employees outside of New York where this is relevant, because the state law either doesn't have a higher threshold or there isn't such a state law at all. But even within New York, the threshold under New York law only applies for the administrative and executive exemptions. It does not apply for the professional exemption. So, for example, if you have accountants doing accounting work, then technically you're not obligated to be paying them this $1,200 or $1,124.20 to maintain exemptions. They are exempt under New York law merely by being a professional, frankly, whether you pay them or not. And the FLSA would then kick in to say, but you do still have to pay them at least $684. So any professionals you have that are currently meeting the FLSA requirement, but not the New York requirement, might at some point, sooner or later, have to get a raise to maintain exemption under federal law, because generally speaking, you have to meet both state and federal requirements. Public employers in New York are typically not subject to the state requirements as well. So there are public government employers that are employing even administrative or executive exempt employees at rates that eventually would not meet the FLSA requirement. So in those different categories, the FLSA threshold can indeed be significant. And of course, if you don't meet the applicable thresholds, then you lose the exemption. Before I get to a string of different New York State updates that you're all going to be interested in, I should note that, of course, there is also litigation attempting to block the FLSA rule. This has happened before. The last couple administrations have proposed FLSA rules, the overtime rules. There was a prior rule that tried to have automatic indexing, and that was at least temporarily blocked. So, expect a likelihood, again, of some court in Texas putting a stop, at least temporarily, to the rule taking effect before January 1st. That's no guarantee, however, and what the ultimate outcome of any change in the FLSA salary requirement will again depend on both the courts and the federal presidential election over time. So unfortunately, it's another stay tuned, but I want to at least make sure you were aware of the different distinctions between New York and federal overtime requirements and thresholds. So if you're lucky, you don't have to get too upset or too concerned about what's going on, because it may not really affect your company. Or if it does, you understand where and how it does. Finally, I want to note that the professional exemption under the FLSA has no salary requirement for doctors, lawyers, and teachers. So while New York has no salary requirement for professionals generally, if they otherwise meet the criteria for professional exemption, the salary requirement at the FLSA level applies to professionals other than doctors, lawyers, and teachers. Again, assuming they're actually engaged in performing those positions. So we're going to wrap up with New York State updates. When I say wrap up, I don't mean that we're almost done. Again, we have another half an hour, including the question and answer scheduled. There are several items of significance that will apply in New York based on recent changes to New York law. There are some carve-outs here for certain categories of employers, so be on the lookout if that might apply to you. Okay, so first I threw up a slide actually from my 2023 New York employment law update. The only change, well, two changes, but primary change on this slide from last year is that I put the date 2023 in red to note that this is what happened last year. So these changes have been in effect for almost exactly a year now. The primary change through the New York Nursing Mothers in the Workplace Act last year was to extend some requirements regarding rooms at work where employees could go to express breast milk after they'd given birth. So this was to obviously provide as comfortable of a setting as reasonably possible under the circumstances for nursing mothers to pump at work. So those requirements had some limited exceptions in cases of undue hardship, and there was a new requirement of a written policy. And that's the only other change to this slide from last year is the Department of Labor has since prepared that policy. My interpretation of the law is that New York employers are now required to adopt that policy and have in place that policy prepared by the Department of Labor. It is not intended as a model policy. It is, in fact, intended as a mandatory policy. Again, the mandatory policy does allow limited exceptions in case of undue hardship. It's just not conceivable for the company to afford to create this type of space that's not otherwise available, for example. Why did I put all that back up there? Well, now in 2024, we have some further amendments to the same law that was being addressed here last year. But this time we're going to provide some paid break time. In 2007, the law was first passed in New York to require employers to permit employees to take reasonable unpaid break time to express breast milk. And then we had those amendments from last year, which expanded the requirements for where they should be allowed to do so. And now, effective June 19th, 2024, all employers in New York must provide paid break time for 30 minutes, comma, and permit an employee to use existing paid break time or meal time for time in excess of 30 minutes to express breast milk. Then it picks up to say, each time such employee has a reasonable need to express breast milk. There's certainly some room for argument and ambiguity here, but what many interpreters believe this rule provides, or this law, in fact, statute provide, is that all employers must allow employee paid break time for 30 minutes each time the employee has a reasonable need to express breast milk, with an understanding that that is likely to occur multiple times during the average work shift. Meaning, at the end of the day, that employees might have the right to say an hour and a half to 2 hours of paid break time to essentially pump for up to the first 3 years following the birth of a child. There's a plausible interpretation that the legislature only meant that paid break time had to be allowed 30 minutes a day, but that if there was other existing break time or meal times that exceeded 30 minutes, then that could be used for subsequent pumpings. But the reality here is that in an average 8-hour shift, the employer may be required to allow the employee to spend 2 hours of it pumping breast milk with pay. Good, bad, or indifferent, the next question arises whether the employer can then require the employee to make up the extra time. Granted, it would almost certainly have to be then with further pay, but if you normally work 40 hours, you're going to spend 8 hours of that pumping. Can we have you work another 8 hours? There is language in this law that says that the employer cannot discriminate or retaliate against someone for taking this break time, and requiring somebody to work extra time because they've taken this break time may constitute a violation of that requirement. So I think this is going to create some legitimate financial and practical concerns in many workplaces, but this is another of the state's effort. Obviously, you can see evolving over time to make life better for nursing mothers at work. Interestingly, I suppose it almost incentivizes in some way employees or some employees to nurse rather than feed their child through other means. Of course, there's also no guarantee that the parent is, or the mother is actually going to be providing the milk to their child. There's probably no way for employers to police that, but again, that's what the law seems to require at this point. In addition to this ongoing focus on pregnancy and maternity-related protections, there is, effective January 1st, 2025, going to be a new, essentially annual paid prenatal leave requirement. So this, in a sense, extends the existing paid sick leave law to require that employees have up to 20 hours of prenatal leave during any 52-week calendar period to be used for healthcare services received by an employee during their pregnancy or related to such pregnancy, including physical examinations, medical procedures, monitoring and testing, and discussions with a healthcare provider related to the pregnancy. While the law is careful not to use the term mother or woman, it does appear to be pretty clearly focused on the employee who is actually pregnant, not a spouse or co-parent or other parent, however you want to describe it, who is not themselves personally pregnant. That actual previous law we were talking about, the lactation law, at some point it amended the word mother to employee, and they're using that word here too, but we don't, meaning every analysis I've seen and myself don't believe that the use of the term employee is meant to extend this leave to people who are not personally pregnant. But of course, if you are pregnant, then your 20 hours for any of these types of services has a fair amount of leeway as long as there's some sort of medical connection. It doesn't appear to mean just going shopping or anything like that, even if you're buying something for the child to be. But again, the wording is a little awkward, 20 hours during any 52 calendar week period. I mean, in most practical senses, this likely is going to mean 20 hours of paid prenatal leave per pregnancy. If somehow you can be pregnant twice within a 52-week calendar period and at the same time not have exhausted your 20 hours, or you know what I'm trying to say. I think, like, if you took your prenatal leave more than 52 weeks before your second pregnancy, then apparently you have another 20 hours. The key point here, or a key point here at the bottom, is unlike the paid sick leave law, which you can require employees to take in 4-hour increments, this 20 hours of paid prenatal leave has to be permitted in hourly increments. So theoretically, a pregnant employee could take 20 separate 1-hour paid prenatal leaves for any given pregnancy. Sort of a related, in a sense, topic. I mean, it's kind of addressed similarly in a lot of discussion of the budget legislation where these provisions were included, is the final repeal of the paid COVID-19 leave that has now been on the books for over 4 years. So everybody was expecting that this law would be repealed this year. What's interesting is that, in fact, it is being repealed, but not until July 31st of 2025. So as of now, that COVID leave law is still on the books and will be for over another year. That being said, there is some uncertainty whether it's still practically available in most cases because of the current guideline, which really doesn't require hardly anyone to quarantine or isolate just because they've contracted COVID-19. The law, as it was drafted and has been in place since 2000, required that there be an order of quarantine or isolation from the government, a Department of Health, for example. And obviously in the height of the COVID pandemic, that was pretty much a formality. There was an affidavit online that any employee could download and sign, and that was supposed to be deemed sufficient. Now, the Department of Labor, at least, has taken the link to that affidavit down. It's at least debatable whether any employee can actually use this leave, even though it's still on the books until next year. So if you do have that situation, you probably want to check the latest guidance from the Department of Labor and the New York Department of Health, and maybe consult with, legal counsel to determine whether the employee in question actually has a right to any further paid COVID leave. I did a question come through whether the paid prenatal leave is on the state level or the federal level. It is on the state level. That's everything I'm talking about now is New York State law. That paid prenatal leave, I believe, is part of the New York sick leave, in which case it wouldn't apply to government employers. So private sector, for-profit or nonprofit, but not the government. A couple quick updates on paid family leave benefits, just because I provided this in the past, and it's somewhat interesting to be reminded of. So, originally when paid family leave took effect, it was phased in as to both how much employees could be paid and how long they were entitled to leave. For some time now, we've been up to a potential maximum of 12 weeks of leave per year. These numbers have also changed, but have leveled off at employees being able to get benefits at the rate of 67% of their average weekly wage, capped at 67% of the New York State average weekly wage, which is determined annually. For 2024, the New York State average weekly wage, which you might just be interested in generally, is calculated at $1,718.15. Therefore, the maximum weekly benefit, that might have been the 2023 maximum weekly benefit. You'll see in a moment on the slide exactly what applies now. So that is the 2023 maximum weekly benefit, or 2024 maximum weekly benefit. I just didn't change the number from 23 to 24. Here you have the change in the maximum weekly benefits since 2018 when paid family leave took effect. You can see that we are now more than, or really close to double what the original maximum benefit was. On the other hand, there's also changes to what the employee contributions are, as most of you know who are subject to this. So again, that carves out most state or local government employers. Employees can be required to contribute to the cost of the paid family leave insurance, and that again is a rate set annually. For 2024, employers can contribute up to 3.73%. That's 0.373% of their gross wages per pay period, with a maximum annual contribution. And the maximum annual contribution for 2024 is $333.25. For those of you who don't already know, the drum roll on that is that this is a very significant decrease from last year's maximum annual contribution, which means that employees effectively have an extra $66 in their pocket just on the basis of this change, assuming they otherwise made enough over the course of the year to submit the maximum contribution towards this insurance, down overall about $90 from the peak in 2022. Still up considerably from where it started in 2018. But as this is intended to be an entirely employee-paid program, the fact that the contributions have not only leveled off, but started to go down meaningfully is at least a good sign that the program is being sufficiently funded and that employees are getting some relief. Now, of course, with the the maximum benefit going up as well, the employees who are actually able to use paid family leave are benefiting for sure, but even those who are not losing as much in wages as they have been the last couple of years. Another New York state law that recently took effect affected employee social media accounts. This law took effect March 12th. And in what frankly is a pretty poorly written statute, it protects employees' quote personal accounts, where personal account is cumbersomely defined as an account or profile on an electronic medium where users may create, share, and view user-generated content, including uploading or downloading videos or still photographs, blogs, video blogs, podcasts, instant messages, or internet website profiles or locations that is used by an employee or an applicant exclusively for personal purposes. Whatever all that means, it basically means social media, which everybody has known that that's what social media was for the last almost 15 years now. And when these laws started coming into being in various states, why New York is only now getting in on the game so late and still not able to more succinctly identify this as a social media or, whatever, use the word internet more generally. But anyway, what's important is we know this is social media accounts. So what the law has to say, it says that employers are prohibited from requesting, requiring, or coercing any employee or applicant to do any of the following. And again, I said here regarding personal social media accounts, the law says personal accounts. They can't do any of these things requiring them to disclose any password or other authentication information. I think that part's pretty straightforward. You can't tell an applicant or employee, I want your Facebook password. You can't access their personal account you can't require them to access personal account in the employer's presence. Basically the same thing. You don't have to give me your password, but you got to type it in and let me see everything. And you also can't request, require, or coerce employees to reproduce any photographs, video, or other information contained in a personal account that was accessed through the above prohibited means. Here's where the debate comes in. Does this mean that an employer can't require an employee to provide a screenshot, for example, of something on their personal social media account in the case where the employee is investigating or trying to investigate, say, an online-based sexual harassment complaint? By asking the employee to provide that, are you in violation of this new law? Well, arguably that's reproducing a photo, video, or other information contained in a personal account, but was it accessed through the above prohibited means? You didn't require that person to give you their password, and presuming you didn't require them to access it in your presence, then maybe that third bullet doesn't apply at all. There's some debate over what that means. And that is the most troubling part, because that makes the whole distinction of whether this law is, in most cases, much ado about nothing, or whether this law is a very meaningful limitation on an employer's ability to investigate claims of harassment or other violations or potential disciplinary actions. And I'm not aware of anything that gives any better guidance on that at this stage. There are various exceptions, some of which are kind of redundant and, seemingly unnecessary. Employers can require employees to provide usernames and passwords for accessing non-personal accounts that provide access to the employer's internal computer information systems. Well, yeah, the law only covers personal accounts. So if it's a non-personal account, does it even matter that it's used to access the employer's internal computer informational systems? And do these types of accounts really affect internal communication information systems anyway, or are they social media accounts? There's no restriction on seeking access to accounts used for business purposes. Again, that seems obvious by the definition of personal account, which says purely for personal use. They don't prohibit management from connecting with employees on social media or viewing information that is voluntarily shared or publicly available. Again, the law goes to the trouble of spelling that out, even though there's nothing in the law that would otherwise even suggest that that's prohibited in my view. And then finally, there's a specific carve out that says this whole provision doesn't apply to any law enforcement agencies, fire departments, or departments of corrections and community supervision. So while this provision does apply both to private and public employers, including government entities and agencies, it doesn't apply to those specific types of businesses which are identified there. What are the penalties? Well, again, the statute doesn't seem tremendously well thought out. There are none specified in this new section of the labor law. There are violations. There are general provisions of the labor law that say labor law violations are punishable as misdemeanors and therefore subject to certain fines, which, in the first instance are relatively small. That being said, it does appear on the whole that an employee or applicant might have a retaliation claim if they suffer adverse job actions based on refusal to provide information protected by the law. So if you tell an applicant, give me your Facebook password and username, or I'm not going to hire you, then they probably could assert a retaliation claim under New York law and get all the penalties traditionally associated with employment discrimination and retaliation claims. But that's not specifically identified in this new statute. Finally, last point before questions, and I know I already have several to get to, so keep typing those in. I should have mentioned that I'm going to give you a link to the slides for this presentation momentarily now as well. And if you are attending this and registered for this webinar, you will get an email by tomorrow probably with the approval code if you need the HRCI credits and with a link to the slides. So you'll get it that way if you don't want to download it right now and want to have the information. The final point is a New York City specific requirement. So if you have employees in New York City, then you are required to post this New York Workers' Bill of Rights poster. And what you see on the screen is actually the poster with the various different languages that presumably say know your rights at work. I don't speak most of these languages. The English and the French, I can confirm, say basically that, so I'm assuming the rest do. The primary point of this poster is the QR code or the URL at the bottom, nyc.gov/workers, idea being that employees are supposed to know from this poster that if they go to the link on that QR code or this link, that they can get information about their rights under New York City and other laws. And indeed, you can go to that website and see all those different listings, but it's not the employer's obligation to go into any more detail than what's on this poster, at least under this specific provision. You have other independent rights to post other notices, of course, as you always have. If you have employees in New York City, you have to post this by July 1st of 2024 in the workplace in locations where it's visible by employees. You must also distribute it to employees, which can be done electronically if there's like a intranet or some other means by which such notices are generally provided, which under New York law, they have to be electronically provided. Now, I think that was something that was addressed probably in last year's employment law update as well. As you can kind of see from that poster, there are other languages in which this information is available that you're required to post in if it's spoken by at least 5% of employees. I didn't check, and I wouldn't even be able to because I couldn't recognize all the languages, but I'm assuming that these are the available languages. And by posting this, it really doesn't matter whether 5% of your employees or not speak these various languages. The city has made the poster in such a way to satisfy that requirement. That being said, if you do have 5% of your workers who speak a language that's not reflected on this poster, then you probably would be expected to keep on the lookout to see if the city updates this poster to add that language. The penalties, frankly, seem to be relatively minor. The first violation warrants a warning, and subsequent violations receive a $500 fine. I would say, of course, it's not going to be good evidence against you if you somehow receive a complaint, a violation of some law that otherwise would have been explained to employees on the website that is linked through this Workers' Bill of Rights. So it's probably a good idea to make this posting, but I did want to let you know that those are the penalties, and the information available suggests that they will be handling violations based on complaints, not necessarily conducting audit. But again, that could change. That being said, we're going to go into the questions. Before that, I'm going to pop up the link to the slides. So those of you who want those can get those. Again, you will get, if you're registered for this, you should get an email. And if for whatever reason you don't get the email and you need the confirmation with the HRCI credit approval code or the link, you can always reach back out to me, and you have my information available here. Again, you can find it online easily enough. All right, now I'm going to start answering questions, which won't necessarily be in any particular order. If you have more questions, keep asking them, and I will stay as long as I can to answer as many questions as come in. There's a question. Can I think the question is, can employers restrict what employees post if it relates to the business somehow? I want to say generally this new New York law probably doesn't address that issue. It pretty much just says you can't access their personal account through certain means. As far as what they can or can't post, presumably is going to depend on other company policies as well as other sources of legal protection. The National Labor Relations Act is going to be the primary source of right in that regard for employees in the private sector. Governmental employees would have constitutional rights at some level. How this law is somewhat likely to interact with that consideration, again, is the extent to which it might limit employers' ability to find out what is posted on an employee's personal account. But the law is clear enough that certainly if they're posting it in a way that's publicly visible, then there's nothing stopping the employer from finding out about it, and then we're looking at it or even monitoring it. And then it's a question of whether some other law gives the employee the right to say that or not. Also, when you say if the post relates to business, question becomes, well, at that point, is it no longer a personal account under that New York law, in which case the employer theoretically could require the employee to provide their Facebook password and username. And I think that's a possible argument. The reality is, I don't think there's that many employers that are actively requiring employees to provide their login information to personal accounts in any event. So I think there's a few different avenues coming out of that question that are going to depend exactly what is going on. Answered that question. All right. For overtime exemptions, over what period of time? Good question. Okay. Some employees work more than 40 hours one week, but fewer than 40 hours the next week. How responsive to these fluctuations do employers have to be? Well, that's somewhat complicated. The bottom line is they have to be paid the minimum salary level for any work week in which they perform actual work. There are some permissible deductions, including personal days for which there's not personal leave available. So if an employee is normally paid $2,000 per week to work 5 days, and they just say, I'm taking Friday off, I don't have any time to cover it, but I'm just not working, then the employer potentially could just pay $1,600 that week instead of $2,000 that week. The specific question is, say you're, I think, paid on a 2-week pay period. So each check is for 2 weeks of pay. Is the pay based on 40 hours one week and 40 hours the next week? I mean, assuming they're actually being paid on a salary basis, then it normally wouldn't matter. If they're paid $1,000 a week, if they're paid weekly, they're getting paid $1,000. If they're getting paid biweekly, they're getting paid $2,000. Where the sort of fluctuation issues more often come up is for hourly employees who wouldn't be subject to the exemptions anyway. And then the question is usually, can we look at the time over 80 hours over 2 weeks to determine whether they're entitled to overtime or not? So that is a different calculation. I mean, typically you're supposed to look at the actual 40 hours in a specific work week on that calculation. There is, though, the scenario where employees normally work different amounts of time in different work weeks. If, for example, there's a rotational based schedule and somebody's expected to work 3 shifts one week and 5 shifts the next week, then, in theory, they make more in the weeks that they work 5 days and less in the weeks that they work 3 days. However, there is some requirement that the salary be consistent on a weekly basis for the exact number. For any number of hours worked to maintain the exemption. So you shouldn't necessarily be paying people more one week and less the other week. That being said, there are a lot of details in between the nuances of what I just said that could determine a different outcome in a specific situation. So I'd have to know more specific details to answer that question any better. Another question, we hire summer interns who earn credits at college for working in an architecture firm. Does the overtime law apply to them? A couple different things. One, there's differences between state and federal law. So whether they are employees or not employees is a question that could have different answers under state and federal law. The idea ultimately being, in most cases, if they are genuinely earning credits through a college program, then there's got to be some analysis of whether they are primarily benefiting themselves or primarily benefiting the employer. So if they're doing work that you would otherwise be hiring non-students to do, then they could be deemed employees and still subject to minimum wage and overtime requirements under state and or federal law, where the answer might be different depending on the circumstances under the respective laws. If, on the other hand, they are only getting credit, not being paid anything, and they're basically requiring the employer to expend additional time training them, overseeing them, finding something for them to do, to the extent that they're basically in the way, and presumably the company's motivation is just, well, we're exposing them to our business and maybe they'll want to work with us later, or this is just a positive thing for us to contribute to the profession that we're in, then in those cases, there certainly are scenarios where those individuals would not be considered employees who have to be paid minimum wage and or overtime. But again, there are just so many different nuances, and you'd want to be careful to know exactly which laws apply under your specific circumstances. Are there any exemptions for creative professionals? Yes. So the exemptions, again, can vary from state to state, but if we're talking about in New York and or under federal law, there are professional exemptions. Professional exemptions generally include both what are called learned professionals and creative professionals. A learned professional, we just had a question about architecture firm, an architect who went to school and got a degree in architecture and then is practicing in a firm as an architecture, presumably in most cases is a professional. There would be some line at which the work the person is being done wouldn't make them eligible for a professional exemption if they're doing pure drafting of a routine nature that they didn't actually need the degree for, then and I'm using this as a hypothetical, then they may not qualify for the professional exemption. And in a related sense, the fact that someone didn't go to school to become an architect doesn't necessarily mean they couldn't qualify as a professional If they just happen to be a self-taught, highly accomplished designer, artist, whether it be painter, drawer, sculptor, what have you, they could still qualify on the creative professional basis. Again, in New York, there's no minimum salary requirement for the professional exemption, but under federal law, those types of individuals would still be subject to the salary requirement, the FLSA salary requirement, which is subject to the new rule that may or may not take effect, but at this point is, I think, $684 per week. Only exception from that requirement under the federal law is for doctors, lawyers, and teachers. What are the required documents for an independent contractor? Well, I'm not exactly sure which side you're coming at it from. But to be specifically responsive to that question, the required document once the Freelance Isn't Free Act takes effect will be the contract, which right now there's not even specifically in most cases a requirement that there be a written contract. There will need to be a written contract. Incidentally, the law requires not only there is a contract, but that the freelance worker is provided a copy of the contract. They can't just be asked to sign it and then not given a copy. Not that would be great practice anyway. As far as insurance types of issues, generally that's up to the parties to negotiate. So there are best practices involved, and normally it's a good idea for the parties to decide who's providing insurance or not providing insurance. And ideally, to maintain the independent contractor designation versus employee designation, you would want the agreement to put all the burden on the independent contractor to provide their own insurance and not have them be subject to the extent possible to the quote unquote hiring parties insurance. This brings up a good point. My understanding is, although I haven't used it, that New York City, because its law has been around for a while, has a model contract under its Freelance Isn't Free Act. The sense is that that's not a very good document to use. The New York State Department of Labor is expected to provide a model contract, and the expectation is that probably won't be what most sophisticated hiring parties want to use either. You probably want a more thorough independent contractor type contract that addresses many things along the lines of these insurance types of issues. A lot of these factors dictate whether the person is in fact eligible to be considered an independent contractor versus an employee in the first place. What is the minimum number of employees for an employer to provide health benefits in New York State? Well, there are two different ways to interpret that question. One is what's the minimum number before you have to provide it, and what's the minimum number before you're able to provide it. Not sure exactly which one is being asked. I'm assuming it's what's the minimum number before you have to provide it. I think at this point the answer is you technically don't ever have to provide insurance, but under the Affordable Cares Act, you potentially are subject to penalties if you're not providing it once you have 50 employees. As far as the minimum number of employees that you are able to provide it for, technically depends on what you can find an insurance company to write the policy for. So theoretically, you can provide insurance to one employee. Whether you can have a group plan and how easily you can obtain that coverage, is a private matter with the insurance companies at that point. There are thresholds as to what level a plan can be community-based or has to be community-based versus based on the employer-specific experience and stuff like that. But again, the best way to answer those types of questions would be to talk to actual insurance companies and see what they offer. At the moment, I believe I've answered all the questions that I have seen come in. I'm double checking that, but if you have any more questions or anticipate having a question momentarily, type something in so I know that. Yeah, I still don't understand. I mean, that doesn't clarify the question any for me, what you just typed in on that insurance piece. So if you can clarify it any more, then I'm happy to try to review it. But there's no obligation to provide health insurance for employees under New York law, nor is there anything saying you're not allowed to provide it unless you have a certain number of employees. Again, there can be penalties under federal law, the Affordable Care Act, if you don't provide affordable insurance. I believe that doesn't kick in until you have 50 employees, but it's not a New York State requirement. I'm not sure if you're talking about health insurance or disability insurance or paid family leave insurance, but and if there is something else, in New York law regarding health insurance specifically, then I'm not aware of it. I will double check, and if I find it, I will let you know. I know I have your contact information. Yeah, I'm not aware of anything you might be referring to, but I will check and follow up with you if I find something. All right. Any other questions? Otherwise, thank you all for joining me today. Look forward to having more webinars soon. Hope to have at least one or two over the summer. And if you're signed up for this one and on that list, then you will get notices of the future webinars. And again, if you have any follow-up questions, let me know. Otherwise, take care. Good luck. Beware whatever happens with the FLSA and FTC non-compete rules, and I am sure there will continue to be plenty more updates from the New York as well as federal level that I will be talking to you about in the future.